of existing courts, full judicial complexes, stone construction, record vaults, multi-story clerk offices. In towns that didn't have paved roads, the investment preceded the apparent need. Take Hillsborough County, New Hampshire. The courthouse opened in 1772. The building included separate chambers for Superior Court, Court of Common Pleas, and General Sessions. Population of the county, 8,400. For context, the entire judicial caseload that year was 63 cases. The building had filing infrastructure for tens of thousands. They built big. Crossed the Atlantic. The Shire Hall in Warwick, England, completed 1758. Capacity for 12 simultaneous jury trials. Warwick's population, 11,000. The county handled an average of 40 trials per year. The building could process 5 times that volume without strain. Same pattern. Different continent. In Philadelphia, the Pennsylvania State House added a dedicated judicial wing in 1736. The addition included 3 courtrooms, a grand jury chamber, and a record storage system using a cataloging method that wouldn't become standard until the 1790s. The design assumed a volume and complexity of legal administration that Philadelphia wouldn't experience for another 30 years. It's not just one courthouse. It's not just one region. It's systematic. The Old Bailey in London underwent major expansion in 1774. The renovation added courtroom space, witness holding areas, and a prisoner transport system designed around a frequency of trials that London wouldn't see until the 1820s. Construction cost £50,000, equivalent to building 60 standard homes. The rationale given at the time, anticipated growth. But growth of what? Court records from the 1770s show trial frequency in London averaging 140 per year. The expanded Old Bailey could handle 600. That's 4 times capacity. For a need that wouldn't materialize for half a century. This isn't infrastructure expansion. This is infrastructure anticipation. In the United States, the pattern intensified after 1800. Between 1803 and 1812, 73 new courthouses opened in counties with populations under 10,000. These weren't temporary wooden structures. Brick, stone, multi-story. Underground record vaults with humidity control systems. The cost per capita was staggering. Jefferson County, Alabama. Courthouse completed 1807. Population, 3,100. Building cost, $24,000. That's roughly $7.70 per resident, at a time when average annual income was $150. The equivalent today would be a county of 3,000 people spending $18 million on a courthouse. For 3,000 people. The architecture itself reveals assumptions. Courtrooms were designed with gallery seating for 200-plus spectators. In counties where the entire adult population could fit in half that space. Record storage systems were built with expansion capacity spanning decades. Filing systems used standardized dimensioning that wouldn't become official until the 1830s. They weren't designing for the present. Look at the floor plans. The spatial organization is nearly identical across hundreds of buildings constructed between 1790 and 1820. Central rotunda. Flanking courtrooms. Basement records. Upper floor deliberation chambers. From Massachusetts to Virginia to Frontier, Indiana. Different builders. Same blueprint logic. The similarities extend beyond layout. Proportional relationships between courtroom size, ceiling height, and gallery depth follow consistent ratios. Door widths match. Window spacing aligns. Vault dimensions scale uniformly. Not exactly identical, but parametrically related. As if working from a common reference. No centralized architectural authority existed. No federal building code. No mandatory design standards. Yet the morphology repeats. In England, the synchronization is even more pronounced. Between 1800 and 1815, 42 shire halls and assize courts were either built or heavily renovated. The projects weren't coordinated by any single body. Different counties, different funding sources, different architects, same decade, same design language, same overcapacity. The timing deserves examination. 1816 is often called the year without a summer. Volcanic eruption in Indonesia. Global temperature drop. Crop failures across Europe and North America. Massive migration. Social disruption. Courthouse construction didn't slow. It accelerated. Between 1816 and 1825, over 120 new courthouses opened in the United States. During a period of economic contraction and agricultural crisis, the buildings didn't get smaller or simpler. If anything, they became more elaborate. Higher ceilings, more ornate facades, larger record systems. Demand should have collapsed. Investment increased. The official explanation holds that legal complexity was rising, commerce expanding, property disputes multiplying. Courts needed to modernize, but the numbers don't quite align. Case volume in most counties remained relatively flat between 1810 and 1830. Population grew, yes, but court filings per capita actually declined in many regions. Yet construction continued at an unprecedented rate. The mismatch raises questions about sequencing. Were the courts built because systems were expanding? Or did systems expand because the courts? The infrastructure tells a different story than the population data. The Erie Canal opened in 1825. Before construction even began, courthouses along the planned route were already being expanded. Monroe County Courthouse in Rochester, rebuilt in 1821 4 years before the canal reached the city. The renovation included commercial dispute chambers and expanded clerk offices designed for high-volume trade litigation. Rochester's population in 1821, 1,500. The building could process the legal workload of a city 10 times that size. This wasn't isolated optimism. It was pattern. Along the entire canal route from Albany to Buffalo, courthouse construction preceded infrastructure completion by an average of 3 to 6 years. Onondaga County, Wayne County, Niagara County, all expanded or built new judicial facilities before the canal brought the commerce that would supposedly justify them. They built the courts first. Then the economy arrived to fill them. The same sequence appears in railroad expansion. The Baltimore and Ohio Railroad began construction in 1828. By 1826, courthouses in planned railroad towns were already being redesigned with dedicated commercial litigation wings. Frederick County, Maryland. Harper's Ferry, Virginia. Courtrooms configured for railroad dispute arbitration, before a single mile of track was laid. In England, the pattern mirrors almost exactly. The Liverpool and Manchester Railway opened in 1830. Court expansions in both cities began in 1826. The Manchester Assize Courts added a dedicated railway and commerce courtroom, 3 years before the railway existed. The timing is difficult to explain as reactive planning. Look at the administrative infrastructure. Court clerk offices in the 1820s were being designed with filing systems that assumed standardized documentation formats. But those formats wouldn't become widespread until the 1840s. The physical dimensions of filing cabinets, the shelf spacing in record vaults, the indexing architectures, all built around document standards that didn't yet exist. As if they knew what was coming. The County Courts Act in England passed in 1846. It standardized court procedures across the nation, filing requirements, case documentation, administrative workflows. But courthouse construction from the 1820s and 1830s already reflected these standards. Buildings were spatially organized around workflows that wouldn't become official for another 2 decades. The infrastructure preceded the codification. In the United States, the pattern was even more pronounced. The federal court system formalized in 1789, but state and county courts operated with enormous variation. No unified procedures. No standardized record keeping. Each jurisdiction developed its own methods. Except the buildings didn't reflect that variation. Walk through courthouses built between 1800 and 1830 across different states. The record vault in a Kentucky courthouse has the same spatial logic as one in Maine. Same shelf depth. Same aisle width. Same environmental control design. Not because they copied each other, most of these projects had no documented contact, but because they seemed to reference a common organizational model. A model that wasn't officially articulated anywhere. The storage capacity is what stands out most. Court record vaults from this period were built with expansion room for 50 to 80 years of case files. At projected filing rates that assumed legal activity would increase by 300 to 500% over baseline. In most cases, that's exactly what happened. But in 1810, there was no basis for that projection. Legal historians point to increasing commercialization, urbanization, property formalization. All true. But those trends were gradual. The courthouse construction wasn't. It spiked. Concentrated in a 15-year window. Then plateaued. The construction wave preceded the social wave. Infrastructure beyond immediate need isn't inherently strange. Cities plan for growth. But the scale here is notable. These weren't 10 to 20% overbuilds. They were 300 to 400% overbuilds. In regions with uncertain growth trajectories. During periods of economic instability, the confidence required to make those investments is worth examining. Take the Hamilton County Courthouse in Cincinnati. Completed 1819. Population, 9,600. The building included courtroom space for 16 simultaneous proceedings. Record storage for 200,000 plus case files. Administrative offices for 42 staff positions. Cincinnati in 1819 had 6 practicing attorneys. The building wasn't just oversized. It was structured around an administrative complexity that didn't exist. Not just more of the same activity, different kinds of activity. Contract law chambers. Corporate dispute resolution spaces. Dedicated areas for commercial arbitration. For an economy that was still primarily agrarian. Yet within 20 years, Cincinnati's legal landscape matched the building exactly. The courtrooms filled. The record systems were used. The administrative staff expanded to meet the capacity. The building didn't feel oversized anymore. It felt prescient. The same trajectory appears in dozens of other cities. Nashville, Louisville, Buffalo, Columbus. Courthouses built in the 1810s and 1820s that seemed absurdly large, then filled naturally by the 1840s, as if the buildings anticipated a specific future. In England, the synchronization extended to procedural architecture. The Court of Chancery in London underwent major redesign in 1824. The renovation introduced spatial separation between different case types: equity, common law, ecclesiastical. Each with dedicated filing, dedicated clerk stations, dedicated judge chambers. But the legal basis for that separation, the formal procedural distinctions, wasn't codified until the Judicature Acts of the 1870s. The building enforced a taxonomy that didn't officially exist yet. The same architectural logic appears in shire courts across England. Spatial division by case type. Dedicated procedural pathways. Administrative separation that assumed a complexity of legal categorization that wouldn't become standard for decades. They built the structure before the system formalized. What makes this particularly notable is the cost. Judicial construction in this period represented a significant portion of public expenditure. In some counties, courthouse projects consumed 15 to 25% of annual budgets. For buildings that wouldn't reach functional capacity for 30 years. The economic justification is unclear. Standard infrastructure planning follows demand curves. You build slightly ahead of need to avoid bottlenecks, but you don't build for demand 3 decades out. The capital cost is too high, the uncertainty too great. Yet that's exactly what happened. Repeatedly. Across 2 continents. In the same narrow time window. The courthouses weren't just big. They were systematically big. Proportionally over capacity in ways that suggest a shared planning assumption. Not wild speculation, controlled anticipation. Anticipation of what, specifically, is harder to determine. Legal historians point to the market revolution. Industrialization. Westward expansion. All plausible drivers of legal system growth. But those processes were underway for decades before and after the construction spike. Why did courthouse building concentrate so intensely between 1800 and 1825? Why that window? The infrastructure suggests something shifted in that period. Not just incremental social change, but a recalibration of institutional expectations. Courts weren't just expanded, they were reconceived. Designed around an assumption that legal complexity would increase not linearly but exponentially. And it did. But the buildings came first. Which raises a question about causation. Did the legal system expand because society became more complex? Or did society formalize its complexity because the administrative infrastructure was already in place? The courthouses created capacity. The capacity invited use. And the use justified the courthouses retroactively. Whether this reflects coordinated planning, distributed intuition, or inheritance of a prior organizational model. The term Tartaria appears on maps from the 16th to 19th centuries. It referred to the vast regions of Central Asia controlled by Turkic and Mongol peoples. A geographical designation, not a unified empire, not a lost civilization. By the 1860s, the term had largely disappeared from cartography as Russian expansion formalized regional naming. Tartaria became Turkestan, Siberia, Mongolia, names tied to administrative control rather than cultural geography. The historical term is not controversial. Its modern reinterpretation is. In recent years, online communities have reframed Tartaria as evidence of a global civilization erased from history. They point to architectural consistency, infrastructure scale, and institutional synchronization as proof of inheritance rather than independent development. The courthouse patterns fit that narrative easily, but they also fit others. 3 models attempt to explain the observations. Model 1, convergent development. Societies facing similar challenges develop similar solutions. Industrialization created legal complexity. Courts responded with scalable infrastructure. The timing clustering reflects shared economic pressures across the Atlantic world. Overbuilding was rational planning for anticipated growth. Model 2, institutional inheritance. The courthouses reflect organizational knowledge transferred through British colonial administration, Enlightenment legal networks, and architectural guilds. The consistency isn't mysterious, it's pedagogical. Designers learned from common sources, applied common principles. Model 3, infrastructural continuity. The buildings weren't designed for future growth. They were repurposed or rebuilt on foundations from earlier administrative systems. The overcapacity reflects prior usage, not prediction. The synchronization reflects renovation of inherited networks. Each model has evidentiary support. Each has gaps. The convergent model struggles with timing. Why did similar pressures produce concentrated building spikes rather than steady expansion? The inheritance model struggles with scale. Legal networks existed, but did they coordinate courthouse construction across dozens of disconnected jurisdictions? The continuity model struggles with documentation. Where are the earlier foundations? Why don't records reference prior structures? None fully resolve the pattern. Return to 1816, the year without a summer. Crop failures, migration, economic strain. Courthouse construction accelerated. That detail doesn't fit clean narratives. If courts were built reactively, construction should have paused during crisis. If they were speculative investments, capital should have redirected to immediate needs. Instead, building continued, sometimes intensified. The Tartaria framework treats this as evidence of reconstruction after catastrophe. But that requires assuming the catastrophe erased not just buildings but records, memory, and continuity, while leaving architectural knowledge intact. Possible, but requiring significant evidentiary leaps. The conventional framework treats it as confidence in recovery. Institutions built for the future they expected to emerge from crisis. Also possible, but requiring unexplained foresight. The evidence doesn't demand either interpretation. It invites examination of what institutional confidence looked like in that period, and what it was based on. The courthouses remain. The capacity was used. The systems filled the infrastructure. Whether that represents planning, inheritance, or something else, the physical record is consistent. Administrative infrastructure preceded administrative need by decades. Not everywhere, not randomly, but in concentrated patterns during a specific window. The buildings created possibility space. Legal systems expanded into it. That expansion feels natural now, inevitable. The courthouses seem appropriately sized for the societies that eventually used them. But standing in 1810 they would have seemed absurd. The question isn't whether the buildings were used. They were. The question is what allowed dozens of jurisdictions to make simultaneous decisions to build far beyond visible need, and be proven correct. Distributed planning networks? Shared institutional memory? Economic optimism? Architectural inheritance? The structures themselves don't answer. They only demonstrate that the pattern existed. The interpretations remain open. The timing remains concentrated. And the courthouses remain monuments to a moment when infrastructure anticipated society with unusual precision. What that precision reflected, we examine. What it proves, we cannot say. The doors are still open. The records are still filed. The buildings still function. Perhaps that's answer enough. Or perhaps it's the beginning of a different question entirely.